Before we get started, we just want to thank Old Republic Surety for sponsoring this episode of Let's Get Surety, as well as NASBP virtual seminars for the 5th year in a row. For more information on Old Republic Surety, visit www.orsurety.com. Now on to our show.
You're listening to Let's Get Surety. Let me hear your bonding talk with Kat Shamapande.
Hey everyone, it's Kat Shamapande. Thanks so much for joining us for this episode of Let's Get Surety. I have with me today my co-host, Mark McCallum, CEO of NASBP. Hey Mark, thanks for being on.
Oh, absolutely. Hi, Kat. Looking forward to it.
Me too. We're going to be talking about the AIA Contract Documents Program today. And to do that, we have with us Sara Bour, Manager and Counsel with AIA Contract Documents. Hey Sara, thanks for being on.
Hey Kat, thanks for having me.
We also have with us Jimmy Germano, Senior Manager and Counsel with AIA Contract Documents. Thanks for being on, Jimmy.
Sure, Kat, thanks so much for having us. I'm really excited to be here.
So before we dive into the topic, Sara, could you just tell us a little bit more about yourself?
Sure. So I am originally from Chicago, Illinois. I'm coming to you from Austin, Texas, though. I've sort of traveled around a little bit and moved to Austin last week, so I'm a new Texan. When I was in Chicago, I practiced construction litigation, which was fascinating, and I would say my practice was about half suretyship and half like general contractors, subcontractors, and owners. So got a really great practice out there in Chicago. And then once I moved, about a year ago, I moved to LA and I joined the AIA Contract Documents Program. So I've been working as manager and counsel and with the Documents Committee for a little over a year now.
That's awesome. So you've got a great background in construction contracts documents that you're bringing to your role.
Absolutely.
That's terrific. Jimmy, can you tell us a little bit about yourself?
Yeah, sure thing. Thanks, Kat. And it maybe sound a little bit similar to what Sara just said, but I am also a recovering construction litigator as well. So I did my undergrad at Cornell, came down to DC for law school, went to Catholic University for law school, and then graduated and got into just sort of general litigation and then started specializing in construction. So construction litigation, start to finish, everything from contract negotiations all the way through to claims, litigation, arbitrations, appeals. And in the DC area, it also involves a little bit more of government contracts versus just sort of straight up construction litigation as well. So a little bit on the GovCon side as well. I came over to the AIA like a year or so before COVID hit. So I think that was about three and a half years ago or so. Time doesn't really exist anymore, but I got to spend a little bit of time at AIA headquarters before everything kind of shut down and we went remote. And I've been there ever since. I've gotten the opportunity to work on a couple different sets of documents that we're going to talk about here during my time at AIA Contract Documents. And then I actually currently just started teaching a class on construction law at Catholic University Law School, which I find to be super rewarding. And our guest speaker coming up soon is going to be one Sara Bour. So I'm very excited about that.
That's terrific. So you're used to sharing information on contracts and teaching people about that.
People want to learn about that stuff. It's mind-boggling to me, but there's a market for it.
Well, this is real world stuff, which you got to experience firsthand in practice, right?
Yeah.
So these are not just words on paper, but have real meaning. I know we'll explore that in just a minute. But Jimmy, I know there's been some changes recently in the Contract Documents Program. Could you tell us a little bit about that?
Sure. Yeah. So in the fall of 2020, the AIA, so the American Institute of Architects is a nonprofit organization headquartered in DC. I think it has about 100,000 members. And there's a team of maybe 20 or so of us that made up the contract documents group at the AIA. In the fall of 2020, the AIA partnered with an entity, a private equity company called True Wind Capital. They're based, I think, in San Francisco, California. And True Wind Capital invested in the AIA Contract Documents program and actually created a separate entity simply called AIA Contract Documents, or ACD for short. And what that did is it allowed a lot more development in things like sort of technology and that sort of thing. So Sara and I technically work for that new entity, but we're still very closely partnered with the AIA to make sure the AIA documents are sort of identical to what you would expect pre 2020, and everything sort of stays the same there, but with some sort of new takes on things as well. So we're pretty excited about the direction of where ACD is going. And then the technology portion of it is actually a term that you may have seen floating around recently, but the AI contract documents are going to be soon powered by a platform known as Katina. So that buzzword Katina that you may be seeing nowadays is sort of going to be the engine that drives the AI contract documents platform. So we're super excited about getting that rolled out.
That is exciting, and I can certainly understand trying to get that marriage with technology. The surety industry is kind of moving in the direction of digitization, trying to move the bonding world, to a digital world, and are looking at blockchain and other technologies. So I commend the AI documents program for being so forward thinking, and we look forward to digital AIA surety bonds. So
yeah, a lot of that exciting. The blockchain, digital stuff, I don't really understand too much of that. I know enough to get me in trouble.
I don't think you're alone, Jimmy.
yeah. So, I think everybody is familiar with AI documents, but there's such a breadth of resources in the form of documents out there. Jimmy, could you kind of give us a rundown of the families that AIA produces?
Yeah, sure thing. And I think that's a really good place to start. So the AI contract documents produces about 200 or so forms, agreements, documents that the construction industry can use. Most of the time, those forms are broken down into what we refer to as families. So the different families can be thought of as different, sort of generally different delivery methods. So you have your design, bid, build. That's what we call the conventional family. If a lot of people are familiar with the A201, that's kind of our flagship document.
Right.
That's in the conventional family. That's a design, bid, build, general conditions document. So from there, you can go into design build. We have a family of design build documents that I'm actually working on right now, and I'm pretty excited about where we're going there. We have construction management, both CMA and CMC. We have interiors, international, integrated project delivery, or IPD for short, program management, digital practice, and then forms. And the forms covers a wide variety of documents. Most of the time, forms are going to start with a different letter, and all these families kind of start with different letters, which is how you differentiate them. Most of the time, that's not true all the time, but that's sort of a good place to start. And the forms is also relevant to your members, is going to be where you find our bonds as well.
Jimmy, could you quickly maybe explain the advantages of working with what I call aligned AIA forms? Why is that important from a standpoint of consistency in language and concept?
Sure. Yeah. So all of our documents are intended to be used together. They don't have to be necessarily. If you have your own general conditions, you can attach that to an A101, for example, but it's not going to work the same way that our documents do in terms of the way that they talk to each other. So the way our documents are set up is that there might be an owner-contractor agreement. So let's go back to the A201, which is our sort of our flagship general conditions document. You have your agreement, which would be maybe an A101. So that's a fixed fee owner-contractor agreement. You would attach an A201 general conditions to that. But then, so those two documents from there, they talk to each other already, so you're square. From there, if you have an owner-architect agreement and you want to bring on an architect, or maybe you already have an architect on board, we have a document, the B101, that marries perfectly with the language and the obligations, the rights, the procedures set forth in the A201 that we already talked about. So those two documents are set up where they talk very nicely to one another. The references are going to cross-reference perfectly. You won't really have to worry about any of that. And you can sort of pick both of those up off the shelf without making any edits. And they're meant to be used in harmony. And it's like that throughout the entire series of documents. So if you pick up a construction manager agreement between, an owner and a construction manager, then there are different agreements that sort of dovetail from that all are meant to be used in conjunction with each other. And there's a lot of resources on our website that kind of talk about which documents go with each other. And there's different colored diagrams and all that kind of stuff to sort of help you choose where to go.
That's a great point, Jimmy. So again, where exactly is that website? What's the website address for those resources?
Sure. So it's aiacontracts.org.
Oh, perfect. So Sara, I wanted to ask you, as a former litigator, and I'm sure you did a lot of support for clients before litigation when they were forming contracts and so forth. So can you truly just take something off the shelf as a client, or does the client need to go and talk to a construction lawyer and make sure that, for example, local laws are addressed? What's your advice about that?
Well, I think everybody should always read the contract. So I wouldn't suggest just taking it off and signing it. Make sure you know what you're signing first. Man, did I see a lot of cases where people just didn't even know what they were signing. But to answer your question, I think these contracts are prepared to be signed. They don't necessarily have to be reviewed by an attorney, but we certainly suggest to do so. Each and every state, there are 50 states out there and 50 different variations of laws out there. So we always recommend confirming that your contract complies with the governing jurisdiction before signing it. But these are contracts that are prepared to be signed right off the shelf.
And I imagine there's a bit of case precedent construing a lot of the language in AIA forms, because many people probably don't know the full history, and it's a lengthy history. So Sara, why don't you tell us a little bit about some of the history of the AIA documents program? I think it's pretty impressive.
Yeah, I agree with you. And this is certainly something I did not know when I was in practice. It's not until I started with the AIA contract documents program that I was like, whoa, there is a breadth of history here. So in 1888, like, we go way, way back. We were just talking about blockchain. We're going way back. A different era. 1888, the AIA first published its uniform contract, which was its first standard contract between owner and contractor. It wasn't until 1911 that this document then became two, with the business conditions in one, and what Jimmy was referring to earlier, the general conditions, were then contained in a different document. And this is now known as the A201. So way back when, the program was initially focused on the design, bid, build, delivery method, but the library has since expanded to include pretty much every major delivery method that you're seeing out there in construction. So also, to play off what Jimmy was saying, our library now includes coordinated sets of agreements and specialized forms and exhibits. And I think something else that I wish I had known when I was in practice that the AIA contract documents program puts out are these incredibly helpful reference materials. So on our website, you can find reference materials such as commentaries, comparatives between document editions. So you can see like the red lines between the 2007 version and the 2017 version of the A201. Some guides for supplemental terms and conditions, and then these little golden nuggets of guides that explain how AIA contract documents are used to address some project-specific issues. And these guides also have recommendations for where to include project-specific requirements and information in the documents, and then just like real world experience and suggestions and recommendations. It's really some useful material on that website.
That's terrific. So it's not just the documents, there's also resources to help you better use those documents.
Exactly. And just overall how to have a better construction project.
And with such a wide breadth of documents and resources, I can't imagine that there's one person putting these together. How do these get developed?
Right? Contrary to popular belief, it is not just one or two attorneys sitting in a room by themselves and making a few edits here and there.
That's me and
That
Sarah.
sounds like an unwieldy project.
Me and Sarah just cranking out.
Putting a few red line edits here and there and calling it a day. So the reality of how these documents are come into shape is really extensive and involves so many different people from all across from different industries and all across the country. So this is what we call the AIA Documents Committee, and it's comprised of about 30 to 40 industry experts from different geographic areas and practice types. So we have people with backgrounds in architecture, insurance, construction law, owners, contractors, and they all work together and revise the documents over a 10-year term.
I think that's an important point. Sometimes you hear people remark that, well, AIA contract documents are written by architects for architects, but that's not really quite right, is it? So you have a committee that is fairly diverse to begin with, and you may have folks working in owners, construction services, or design departments, and as you said, around the country, and even some, maybe I imagine, design builders and that sort of thing. So could you tell us a little bit more about how many individuals are actually in those working groups?
Yeah, I don't know the specific numbers off the top of my head as to who is from what background, but I do know, and that's probably just because I've been working with the program for about a year now, still getting to know
Sure.
everybody on there. But I do know that, though I don't know the specific numbers, most people on the documents committee have backgrounds in architecture and construction companies, building owners, and developers.
Great. And Jimmy, I imagine that the program does outreach. I know historically it did, and I imagine it still does, particularly on a given document. Is that true? And who do you make that outreach to?
Yeah, good question. And this is a favorite topic of mine, because one of the first things I worked on when I started with the AI contract documents program a couple years ago, was sort of revamping the internal system by which we cataloged this information. So it is near and dear to my heart. I love a good Excel spreadsheet. So I used a good Excel spreadsheet to keep all this information in there, and went down a lot of wormholes on the internet trying to learn Excel. But that all of that is to say, so the AI contract documents are updated usually on a 10-year cycle. So the contract documents program that Sara talked about, those committee members volunteer for a 10-year commitment. So it's a pretty significant commitment.
Wow.
And
Wow.
The reason why it's a 10-year commitment is because the documents are updated on a 10-year cycle. So it allows us to utilize that institutional knowledge that's gained from somebody who may have worked on the 2017 A201. They're going to be around in the lead up to 2027. So they can say, here is why we made a specific change. Here's what we were thinking. This is why it's written a certain way, et cetera. And having that is very, very useful. So we don't just kind of revert back or not really understand why certain changes were made. So within the 10 years, let's take the A201 because it's kind of the one of the more well-known documents. So between 2017 and 2027, that document is going to be live in the industry. And what's happening in that time is it's being negotiated on projects. It's being maybe litigated in court. It's being arbitrated. It's going through claims processes. It's being analyzed in articles, in law journals, on websites. Everyone is kind of giving their take on the new edition. In the 10 years, we are receiving that information and we catalog it. So that might take the form of a published legal opinion. So the Fifth Circuit Court of Appeals might issue something that says, we are interpreting the A201's waiver of subrogation to mean X. Well, we take that opinion, we write a memo on it, we save it in the file. And that might be in 2019. Well, in 2020, we might get a phone call from an attorney in, Arizona who says, hey, I'm using your 821. I don't really understand how this clause relates to that clause. And we say, you know what? Maybe we could make that tie a little bit more clear. Let's remember that. And then in the next year, et cetera, et cetera. And you can see how over the course of 10 years, that hopper gets very, very full. And we have a long list of things. So that's where we start. So in 2024 or so, about 3 years beforehand, we will start working on the A201. And the first thing we will do is dust off those comments from 2017, 2018, 2019, 2020. And we'll start going back and saying, all right, how do we make this document even better so that in 2027, we're giving the industry the best possible A201 we can give it?
Yeah. Can I add something to that? I think a really useful part of our website is what's called Doc Info, and that's where people can submit questions related to the documents. And this is another one where we get some Doc Info questions, and we're like, oh, that's a really good question. That's something that we should consider when these documents come up for updating on the 10-year cycle. So we'll actually take some Doc Info questions and catalog them, as Jimmy was just mentioning.
Oh, that's great.
Yeah.
Well, yeah, I know not every document is done on a 10-year cycle. The bond forms would be an illustration of that. But we were fortunate to be able to give feedback, that is the NASBP, on the revision of the bond forms that are now out there, and including a suggestion that there be a warranty or maintenance bond form, which then came into being. So I know that AIA is very receptive to that kind of feedback from interested parties.
Yeah, so the AIA partners closely with a lot of industry organizations and experts in the field, like yourself, Mark, somebody who really knows the surety market. And in the lead up to 2020, I think, which is when we released the warranty bond, we worked closely and with your organization, with a lot of other surety, insurance, legal professionals to make sure that new product was going to give sureties and owners and contractors exactly what they wanted and kind of what they expected from a warranty bond. And so the probably should say this because it would be helpful to your members. So the AIA publishes, I think, 4 bonds at this point. We have a bid bond, we have a performance bond, a payment bond, and now we have a new warranty bond. Most of them are sort of built on the same general chassis. Some of the language looks pretty similar throughout, especially the payment and performance bond. And then the warranty bond was we started with, I think, the performance bond and then made some edits to say, this is a warranty bond, that the obligations are going to be slightly different. And if you'll indulge me, if I can nerd out on a legal issue that I think is really fascinating
Absolutely.
in the warranty bond. So one of the things, if your members are used to a performance bond. So a performance bond, the language in the AIA's performance bond, and most performance bonds in the industry, is going to require an owner to declare the contractor in default. You have to have, and to declare the contractor in default in the contract, you have to have a material breach of the contract. Well, a material breach of a construction contract, by definition, arguably, cannot occur after substantial completion, by definition. Because if you've substantially completed the contract, you can't materially breach it anymore because you have fulfilled your obligations, and now it's just punchless work at that point. So we went around and around to say, all right, well, in a warranty bond, we can't have the obligation be for an owner to declare the contractor in, quote, default, because they've already performed the contract. They're just now doing warranty work, and that's not a substantial breach or a material breach. So how do we do that? And in the lead up to that, Mark, if I remember correctly, you commented on this exact issue and kind of said, this is how it's usually structured. This is how it's underwritten. This is how it's understood in the industry. So what we did was we basically gave it like a, sort of a halfway approach and said the owner has to give notice to the contractor of a breach of its warranty obligations. So it's not a full-on default per se, again, because the contractor's already substantially performed the contract, but it still gives the owner the right to say, we are triggering the warranty bond obligations. You have to come back and fulfill your warranty obligations. And if you don't, we're pulling in the surety. So that's sort of just one little legal nugget in there. That's kind of what we were saying earlier, and going back to that, you can pull that off the shelf and know that a ton of thought went into every single word, every single comma that's in there to sort of anticipate what the needs from the industry are going to be.
Yeah, no, it's a great point. The surety industry notice is near and dear to our hearts. So we certainly appreciate that structure. What also is near and dear to our hearts is that there's an equitable apportionment of risk, and that's why we are very much advocates for AIA documents and similar documents that imbue that kind of philosophy. Maybe, Jimmy, tell us a little bit more about some of the core principles that apply to the AIA drafting process.
Yeah, sure. And so construction is risk management. I mean, that is what you are doing. When you sign a construction project, you are allocating risk. And I use the word allocating on purpose because when you're talking about the contract negotiation side, there isn't any risk yet. The project's just theoretical at this point. So you are simply allocating risk. And then during the project, you manage that risk. So I think to say contracts manage risk, they do, but I think a more appropriate nomenclature is to say they allocate risk. And the way that the AIA contract documents allocate risk is as follows. So the first thing we do is strive to have everything be allocated in a fair and balanced manner. The way that we do that is we place the risk on the party who is in the best position to manage it once the project gets started. So if you're talking about something like differing site conditions, right? Differing site conditions ultimately benefit the owner because back in the 40s and 30s, when differing site conditions, that clause and that concept came about, it was to give the owner a more uniform set of bids. The contractor didn't have to underwrite, and anticipate DSCs when they submitted their bid because they knew that risk was going to be shifted to the owner. But as the project's going, who is the party who is in the best position to, when they're digging on the project and they encounter, rocks that are much larger than they thought, who's in the best position to manage the risk of not having that slow down the project? It's the contractor. So the contractor is the one who has the responsibility to give notice to the owner and say, we encountered a differing site condition. Here's the way it's going to affect the project. So the first thing we do is we say, all right, let's identify a risk and let's give it to the party who is in the best position to manage it. The way most of the time that you manage risk is through insurance. So most of the time, the party who's managing the risk can pass that through to their insurance company. And that's in exchange, obviously, for premiums. If there is a risk where no party can manage it, then the risk goes upon the owner. And the reason is because the owner is the one who ultimately is the beneficiary of the project. They are the one, when all is said and done, the dust settles, the project is over, they're the one that's benefiting from project ownership. So they are the one that should manage those risks where everyone is on an equal playing field insofar as no one can manage a certain risk. So for example, risks like weather delays, things like that no one is really in control of. The owner usually bears those risks, not because they're in the best position to manage it, but because at the end of the day, they're the ones who are benefiting from project ownership.
So Sara, I'm going to tap some of your history as a construction litigator and ask you, I imagine that you saw some imbalanced contracts out there that maybe didn't have that fair apportionment of risk. From an end consumer standpoint, tell us why that's so important to have that balancing, and when it's not balanced, what kind of repercussions occur?
Sure. Yeah, I saw quite a few what I would consider bad contracts out there, and those are really one-sided. Hey, if we don't get paid, you're not seeing a dime from us. And so I think I saw two major repercussions from bad contracting or imbalanced contracts. One, there were terms in these contracts that weren't necessarily um, enforceable in
Mm,
Illinois, where I was. They might have been
Okay.
enforceable in a different state, but like in Illinois, for example, pay if paid clauses are unenforceable by way of
mm,
public policy. And so if you're going to have a pay if paid clause in there, well, you wanted to rely on it, but under Illinois law, that was unenforceable. And then the other just unfortunate downside of bad contracting or imbalanced contracts is that somebody, perhaps it's usually the downstream contractor, is the one who perhaps performs a lot of work and doesn't get paid, and then at
mm,
the end has to fight tooth, claw, nail to get paid. So it creates contentious relationships on
mm.
projects, and so that's just ultimately not great for any construction project.
Those are great points. I kind of to maybe sum it, it's like, well, in the end, it's time and money, and that's exactly what you want to be cognizant of. And when you
Mhm.
use that one-sided contract, that's what you're sacrificing, in effect. Um,
Yeah.
so we talked a little bit about the AIA documents and their longevity, and why that is so important. Where do you foresee the program going in the near future? Is there anything on the horizon that the industry should be aware of, Jimmy?
Yeah, sure. It's a good question. I guess the first thing to remember with AI documents is it's most of the time it's pretty easy to know what we're working on because we update all of our contracts on a 10-year cycle. So those documents that were published in 2012, 2013, 2014, that's what we're working on right now. So for example, I am working on the task group that is redoing the A141 and its associated documents. So that's the design build family. The design build documents were last updated in 2014, so they're going to be published again in 2024 on their 10-year cycle. And we started that process about a year ago. So it's a 2 or 3 year cycle to update the design build documents because they're so complex. There's so many interrelated parts. There's a lot of exhibits to those documents and general conditions. So in one sense, it's pretty easy to know what we're working on and what's coming out next. But having said that, there are some things that we are that sort of go, first of all, off cycle. So they might not be updated every 10 years. It might be 9, it might be 10, 11, 12. And that's just sort of how the production schedule lands. The important documents are always 10. There might be a little change here and there, but by and large, the industry can anticipate a 10-year cycle, which we think is important, right? Like you don't want to negotiate a contract and then come back a day later, like, I just bought a new iPhone and then come to find out they just dropped a new one. And now I'm like, well, now I'm
Yeah.
outdated. Like everybody knows the next A201 is coming out in 2027. So you can look for that. You can anticipate it. And then around that time, there's going to be a ton of education about what's changed, what's different, what's the same, what types of factors went into it, et cetera. There are some things that we're working on that are a little bit different. And unfortunately, I kind of have to say you'll just have to stay tuned and figure out and find out what we're working on. We can't release some of
Suspense.
that yet. Yeah. But one that was just released, for example, that's near and dear to my heart are BIM documents, building information modeling. So not necessarily affecting sureties, I guess, directly, but affecting definitely where the industry is going from a technology perspective. So we were talking about blockchain and sort of making tech a really integral part of the construction industry. And we think the new BIM docs have really taken a good step forward in how to do that. And so we might take a look at doing some more stuff like that going down the line.
That reminds me of a really wonderful topic that hopefully we'll have on a future podcast episode. Understanding design delegation and responsibility. So, Kat, we should definitely delve on that topic.
Yeah, definitely.
Yeah, yeah. And delegated design is super interesting. I actually the class that I taught last night was about the Spear Doctrine and how delegated
Ah,
design is how the Spear Doctrine affects delegated design and vice versa, and whether or not it applies. And we had a good discussion there. So that is very much delegated design is top of mind right now. So you hit the nail on the head.
Sara, there's some interesting things going on in Texas with the Spear Doctrine. So,
Oh.
you'll get to enjoy that. So Sara, as a kind of a last thought, what would you want to communicate to a surety professional about the AI contract documents and their importance? Maybe a parting thought.
Yeah, I think what's important for surety professionals or any attorney representing sureties is when you see an AIA contract documents bond form, you can predict and know what's in that document. And there's a breadth of case law that you can use to either support your arguments or defeat some arguments. So these are some long-standing documents. They have withstood the test of time, and that's for a reason, because they are balanced and because they are a quality product.
Oh, that's great.
Yeah.
How about you, Jimmy?
Yeah, I think in the similar vein, if I had kind of a parting thought, if you'll indulge me just for a couple minutes, just to tell a bit of an anecdote. In the lead up to
Sure.
the design build documents, we are interviewing what we call liaisons. So industry experts and professionals in the design build world. And one of the people we interviewed is a construction attorney who mostly deals with design build projects and primarily on the public side. So representing not the owner, but maybe the concessionaire or something, the party that negotiates with the owner, contracts with the owner, then maybe subcontracts with all of the other entities, including the design builder. So one of the things that they conveyed to us was how they will use the AIA's design build documents because they are so easy to underwrite from a project financing perspective. Banks and construction lenders, sureties, they know what to expect. If they're handed an AIA document, it is very predictable versus like a bespoke agreement that an attorney wrote just because it's been handed down in their firm for a while or something like that. That's a lot more difficult to do on these much larger projects. And the way that he used that phrasing of underwriting, you're not necessarily talking about sureties when you're talking about the A141, but if you get into the surety world, the bond world, you are talking about like the definition of underwriting from that perspective. So if your members can more easily underwrite a product and a client and one of their insureds, then it just makes their job a whole lot easier. So I would sort of encourage them to look at the AIA process and to understand why these documents are sort of a little bit more predictable, which would then just sort of help everyone throughout the process. So I would just sort of, I just thought that was kind of an interesting way to look at it, and maybe something that your members would find helpful.
No, that's a great point about the importance to credit arrangements of using an understood and equitable form. That's great.
It's been so great having you on with us today, Sara and Jimmy, sharing so much information about the AIA contract document and the process. I just want to thank you both for being on. Hopefully we can have you back again sometime and get some more of the AIA contract document staff on with us.
You've been listening to Let's Get Surety, Let Me Hear Your Bonding Talk, brought to you by the National Association of Surety Bond Producers. For more information about the NASBP and its members, visit nasbp.org.
Before we go, we just want to say thank you again to Old Republic Surety for their generous support in sponsoring this episode of Let's Get Surety. For more information on Old Republic Surety, visit www.orsurety.com.